The Supreme Court began its new term this month, and Nicholas Iovino and Nina Polano have chronicled the cases with the potential to be big wins for conservatives. The cases before the court are the type that don't usually come up in polite conversation. Guns, abortion, religion. It's going to be a consequential term for the court. But don't take it from me. Here's Nick and Nina.
There's massive, very high red curtains that they part, and then the justices are there, and it's strange how close you are. You're really close physically to them. And because they're sitting in this round, semicircle, it's like you can't even see anything else. Your peripheral vision is all just more justices. So it's a very intense, kind of immersive experience.
That sounds really intense.
It sure does.
So who is that?
That's Ahilan Arulanatham, a UCLA law professor. I asked him what it was like to argue before the highest court in the land. He'll be arguing his third case before the Supreme Court on November 8th.
And what case is that?
It's called Fbiv Fazaga, and it's about whether the government can use what's called the state secrets privilege to block a lawsuit claiming it illegally spied on devout Muslims in Southern California.
That sounds pretty important.
It is, but as you know, it's not the only one. The Supreme Court is slated to hear a host of pivotal cases over the next few months, including on divisive issues like abortion, gun control, and the separation of church and state.
It's also a peculiar moment for the court in terms of its public perception. Some have argued, based on recent decisions, that it's more political than ever, and judges are basically just politicians that wear robes instead of suits.
Some justices have been pushing back on that narrative in recent weeks, including Justice Amy Coney Barrett, who said during a speech in September that the justices don't decide cases based on their political beliefs.
She said, quote, "My goal today is to convince you that this court is not comprised of a bunch of partisan hacks."
This will be the court's first full term with Justice Barrett, a conservative who replaced the late liberal Justice Ruth Bader Ginsburg last year. The court now has a 6-3 supermajority of Republican-appointed justices.
And that's something that has many people on the left nervous about how the court might rule on some politically charged cases. UC Berkeley Law School Dean Erwin Chemerinsky told me this is the most conservative Supreme Court since the 1930s.
The shift in the composition of the Supreme Court is like to make all the difference when it comes to matters like abortion, guns, aid to parochial schools.
The court has faced sharp criticism over some recent decisions on emergency petitions, including its refusal to block a Texas law that bans most abortions after about 6 weeks.
It is nearly impossible to get an abortion in Texas. The most restrictive abortion law in the country went into effect after the U.S. Supreme Court declined to act on a request to block it.
Court watchers and legal scholars refer to these decisions, which are often issued with little to no reasoning, as the Shadow Docket.
Ooh, sounds spooky. Why did they call it that?
The term was coined by University of Chicago law professor William Bode, and it basically means that unlike the merits docket, in which cases receive full briefing, oral argument, lengthy opinions that spell out the reasons for each decision, shadow docket rulings follow a much less transparent process. Sometimes we don't even know which justices voted in favor of a decision unless they choose to write a dissent.
We spoke to some legal scholars across the political spectrum about this, and each of them had different views on the subject. Zach Smith from the conservative-leaning Heritage Foundation said he thinks the term shadow docket is a misnomer.
The term shadow docket sounds nefarious, like there's something, shadowy or sinister going on. But it's really just the Supreme Court's emergency motions docket, which is a docket that every court in the nation has.
But others, like Dean Chemerinsky, said the court has been downright capricious in how it handles emergency petitions in politically controversial cases.
The Supreme Court has been very inconsistent, and when it gets involved, it doesn't get involved. It had no problem getting involved to stop governors from limiting gatherings, including for religious worship, so as to restrict the spread of COVID. The court had no problem in getting involved to stop lower courts from making absentee ballots more easily accessible. But then Texas adopts a blatantly unconstitutional law, and the Supreme Court doesn't want to get involved at all.
Concerns about whether the court is deciding cases on partisan lines are unlikely to go away anytime soon, especially with some of the hot-button cases on the court's agenda this term.
Well, let's jump right in and take a closer look at some of these cases, starting with one that could overturn the nearly 50-year-old legal precedent established in Roe v. Wade.
Right. The case is Dobbs v. Jackson Women's Health Organization, and it concerns a Mississippi law called the Gestational Age Act, which bans nearly all abortions after 15 weeks. Jackson Women's Health Organization is the state's only licensed abortion facility, and the organization sued the state to block the law from taking effect. They won that lawsuit in district court, and later the decision was affirmed in the Fifth Circuit, since the state had not proved that a fetus would be viable at 15 weeks, and Supreme Court precedent says it's unconstitutional for states to ban abortion before a fetus is considered viable. That precedent, of course, is the monumental abortion case, Roe v. Wade.
In a landmark ruling, the Supreme Court today legalized abortions. The majority in cases from Texas and Georgia said that the decision to end a pregnancy during the first 3 months belongs to the woman and her doctor, not the government.
So the Supreme Court will decide whether Mississippi's law is in fact unconstitutional, which means
Roe is dangling over the edge of the balcony and, could get dropped at any moment.
That's Kimberly Mutcherson, co-dean and professor of law at Rutgers Law School in Camden, New Jersey. She explained how, since 1973, Roe v. Wade has guaranteed the right to abortion. Then, in 1992, another case, Planned Parenthood v. Casey, upheld that right. Although, as Professor Mutcherson said, it created more opportunities for states to burden that right. Now, fast forward to the year 2021.
The Supreme Court is being asked to decide whether it is prepared to overrule Roe versus Wade and Planned Parenthood versus Casey.
So let's talk about what that actually means. And first, what it doesn't mean.
If Roe versus Wade gets overturned, it doesn't mean all of a sudden abortion is illegal in the United States. It means that there is no longer a protected constitutional right to have an abortion, and the issue goes back to the states. And so each state individually will get to decide what their laws are on abortion.
And it's not just Mississippi and Texas. Here's Professor Chemerinsky again.
Over 20 states have laws already on the books that prohibit all or virtually all abortions that would go into effect if Roe versus Wade is overruled. Additionally, many other states would adopt laws restricting abortion.
In other words, the ability to get an abortion will be determined by where you live, or by where you have the means to travel.
The reality is that women with money who want an abortion will travel to states where abortion is legal.
And if you can't afford to travel,
it's poorer women and teenagers who again will be forced to make the choice between the unwanted child and the unsafe back alley abortion.
Zach Smith from the Heritage Foundation pointed to what he said could be an issue with the way that Roe v. Wade and Casey were originally decided.
One of the complaints of Roe v. Wade, of Planned Parenthood v. Casey, since those decisions were decided, where the court found a constitutional right to an abortion, is that they were really unmoored from the text, structure, or history of the Constitution. The justices' jobs are to apply the text of the Constitution, apply the text of the laws they're evaluating, and reach legal decisions and not political ones.
We led with discussing this case for a reason. Legal experts tell us that the potential impact of the decision here really can't be overstated.
If the Supreme Court does, in fact, explicitly overrule Roe versus Wade, that is a cataclysmic decision, right? I mean, that is a decision that changes what has been established law in this country since 1973. So overruling those cases utterly changes the landscape on abortion, the legal landscape on abortion in this country. It is a seismic shift if it happens.
There's another important dispute on the Supreme Court's agenda this fall. It will determine if states like New York can restrict a citizen's right to carry concealed firearms outside the home.
From my cold, dead hands.
New York State resident Robert Nash sued the Empire State in 2018, after it denied his request for a concealed carry permit. New York only grants those licenses to people who can show they have a special need for self-defense. Last year, the Second Circuit upheld a lower court's dismissal of the lawsuit, finding it was virtually identical to a previously rejected legal challenge. On November 3rd, the court will hear oral arguments in the case. It's called New York State Rifle and Pistol Association v. Corlett, and the outcome could have far-reaching consequences for gun control laws across the nation.
Many states, like California, have laws like New York's that limits the ability to have concealed weapons. I think if the Supreme Court rules against New York and strikes down this law, it'll put in jeopardy laws all over the country that restrict things like having concealed weapons.
That's UC Berkeley Dean Chemerinsky. He says the idea that the Second Amendment guarantees the right to own guns for self-defense is fairly new. The precedent was established in a 2008 Supreme Court case called District of Columbia v. Heller. That 5-4 opinion overturned Washington, D.C.'s total ban on handguns and voided a requirement that rifles and shotguns kept in the home must stay unloaded and disassembled or bound by a trigger lock device. In 2010, the court went further in another decision, McDonald v. City of Chicago, finding that state and local governments cannot pass laws that interfere with the right to keep and bear arms in the home for self-defense. If the court follows the precedents established in those cases, Zach Smith of the Heritage Foundation says it will most certainly conclude that New York's firearm restrictions are unconstitutional.
So I'm hopeful the court will basically reaffirm their holdings in Heller and McDonald, find that the Second Amendment is not essentially a second-tier right, and really, review infringements on Second Amendment rights very closely, as they do with, First Amendment, free speech, religious liberty claims, Fourth Amendment search and seizure claims, and really make the Second Amendment a co-equal right with those other guarantees found in the Bill of Rights.
But Arizona State University law professor Elon Werman is less convinced that the conservative-leaning court will abolish the power of states to limit carrying hidden guns in public. That's because states and their predecessor colonies have restricted concealed weapons for centuries.
There have been restrictions on gun rights throughout all of American history, including in states that had Second Amendment equivalents, right? Now, if you ask my read of the history, there were tons and tons of restrictions on concealed carry. If you look at all the states, state after state after state prohibited the carrying of concealed weapons.
The question of whether citizens can openly carry guns outside the home is a separate issue, which could soon come before the Supreme Court. That's after the Ninth Circuit ruled this past March that the Second Amendment does not guarantee the right to openly carry arms in public. But on the narrow issue of carrying concealed weapons, Werman believes conservative justices might surprise some on the left by taking a more nuanced position.
I don't know what they're going to do, but knowing them, they care about historical practice, right? And lots of historical practice suggests that prohibitions of certain types of concealed carry were routine. And so I think that's important stuff that they're going to have to look at.
If you think back to U.S. history class, the separation of church and state may stand out as this long-standing tenet of American freedom, a country with no national religion, where your right to gather and worship is guaranteed by the Constitution. But calling into question that boundary between government regulations and religious practices is an American tradition in itself. The first one comes from Maine, where a group of families sued because they were blocked from using a state tuition program to send their kids to Christian schools. The program is for families in areas that don't have their own public schools. The Maine Department of Education provides money for parents to send their children to the school of their choice, public or private. But it excludes religious schools, and the families who lost their case in lower courts want to change that.
If the Supreme Court rules in favor of the challengers and against the state of Maine, it's going to mean anytime the government provides any form of assistance to private secular schools or to parents of children in private secular schools, it must provide that aid to religious schools.
That's Dean Chemerinsky again, explaining the potential impact of this decision. Some legal analysts compare the case to a 2017 Supreme Court decision, which said Missouri could not exclude a preschool from a grant program for playgrounds. But Professor Werman questioned how that reasoning squares with the free exercise clause in the First Amendment.
If a state collects taxes and distributes it for the purposes of public education and excludes religious institutions, how has anybody been prohibited from freely exercising their religion? Nobody has.
But Werman acknowledges that conservative justices like Clarence Thomas and Samuel Alito have made their views clear on whether states should be allowed to exclude parochial schools from state funding programs.
I think they believe that discriminating against religious institutions and the distribution of public monies violates the First Amendment. I think they believe that.
Also grappling with the separation of church and state is a case that comes straight from the heart of the original 13 colonies. It brings us to City Hall in Boston, where officials rejected a request from a Christian group called Camp Constitution to raise its flag above City Hall. As you probably guessed, the flag has an image of a cross on it, and the city of Boston declined to fly it, which it had never done before. Boston usually approves those requests and has flown flags supporting all kinds of groups and causes like Chinese immigration, Juneteenth, and gay pride. The group says that the rejection violates its First Amendment rights. But the free speech argument depends on who's speaking.
If the government itself is the speaker, the First Amendment doesn't apply. On the other hand, if the government is creating a forum for private speech, then it can't discriminate.
Professor Werman thinks that this one will be a pretty clear decision.
Right, Justice Alito, the most conservative, most likely justice to say this is not okay. He said in other government speech cases that the government can choose and decide which speech it wants to endorse, like in public monuments and the parks and so on, as long as it doesn't discriminate against private speech. And so I think that's the obvious answer here. I'm actually surprised that this is so controversial that it's kind of going up to the court.
Taking another view, Zach Smith from the Heritage Foundation hopes to see a win for both Maine parents and Camp Constitution.
I think the fact that the court took both of these cases shows that they are maintaining an emphasis on religious liberty. They're seriously considering and evaluating many of the religious liberty claims that come before the court. And I am hopeful that there will be positive outcomes for religious liberty.
Beyond the hot-button issues of abortion, gun rights, and church and state separation, there are plenty of other important cases on the Supreme Court's docket this year. The justices have already heard arguments in a case involving a Guantanamo Bay prisoner being tortured overseas, a request to reinstate the death penalty for the Boston Marathon bomber, and a dispute that will determine if those wrongly charged with crimes can sue for malicious prosecution after charges against them are dropped. On November 8th, the court will hear arguments in yet another pivotal case. It's called Fbiv Fazaga, and it involves a group of Muslims from Southern California who say the government targeted them with illegal surveillance based solely on the assumption that their devout faith made them potential terrorists. The government says the lawsuit must be dismissed because fighting it in court would reveal sensitive information that would harm national security. If the court accepts that position, plaintiff's lawyer Ahilan Arulanantham says it could have serious ramifications for future lawsuits over covert government operations that violate the law.
If the government can run programs that violate constitutional rights and escape any judicial accountability for those programs because they are running in secret, I think that would have a sort of open a profound loophole in the web of constitutional protections that applies in our system.
As the fall docket stirs up controversy about how the Supreme Court functions, whether it's too political, and how the shadow docket is used, some legal experts are studying ways the court could be changed in the future.
The ideas being floated out there include changing the confirmation process for new justices, setting term limits for these lifelong positions, and even expanding the number of Supreme Court justices.
Some have suggested we should have 13 Supreme Court justices, or that the judges should only serve 18-year terms. Changes like that don't come easy, and any push to reform the court will likely face fierce opposition in the halls of Congress.
Dean Mutcherson said, "We can sometimes get bogged down with assumptions that just because the court has always operated a certain way, it can't change. But those perceptions might be starting to shift."
In my experience as somebody who's been a law professor for 20 plus years now, I've never heard the kinds of conversations about changing the court, serious conversations about changing the court, and the way that we're hearing them now. It's really quite extraordinary.
As mentioned before, this Supreme Court term will be consequential. In a very unusual move, the justices recently agreed to take up Texas's near total ban on abortion and appear to have fast-tracked the case, scheduling arguments for November 1st. To stay up to date with the latest from the court, head over to Courthouse News, where you get the latest news on arguments, rulings, and analysis of the effects of the court's decisions.